All right. Chapter 20, Transfer of Title. In this chapter, we're going to describe the four methods of title transfer and explain the process of transferring title of a deceased person's property. Title meaning ownership. So, title to real estate is ownership of the land. Alienation is a transfer of title to a parcel of real estate. And this can be done during your lifetime or after you die. It could be voluntarily, that means with your consent, or involuntarily without. At death, voluntary alienation is done through a will, or involuntary if no will is left, because the state will get your property by the process of escheat if no heirs can be located and you died without a will, indicating how you wish to dispose of your property. You don't necessarily need to leave it to heirs. You could leave it to friends or acquaintances or charities or what have you. So, title to real estate means the right to or ownership of the land. And then you wrote down here alienation is the transfer of title to a parcel of real estate. Okay. So, voluntary alienation of title can be by gift, sale, or exchange. The owners use some form of deed to transfer that ownership to convey it during their lifetime. Deeds are only used to transfer ownership while you're alive. So, how do we transfer ownership after death? Using your will. Transfer of ownership to or from the government is done by dedication or public grant. Dedication is when we give land to the government for greater public use, like streets, schools, and parks. Has nothing to do with death, by the way. You could be alive and dedicate land to the government. You're giving land to the government for a public use like streets, schools, and parks. Often developers do this when they make condo complexes, right? They have a subdivision. Are they going to keep those streets private or are they going to dedicate them and they're going to become public streets that the city needs to maintain? So, whether they're doing a subdivision, whether it's a condominium complex or if it's a subdivision where they're building a bunch of single family homes, are they going to keep those streets private and then have to maintain them, or are they going to dedicate that land to the government? Public grant is when the government gives or sells land to an individual for private use. The public is granting the ownership.
Is that giving or is it by sale as well?
Either giving or selling.
Okay.
When the government gives or sells the land to a private person, it's by public grant. The public is granting you the ownership. It's just like with private ownership. If I sell my land to you, I'm granting my ownership to you. Okay. So granting is how we, you know, is what we call it when we're transferring the ownership. I'm granting my ownership to you, right?
Got it.
So I'm the grantor and you're the grantee. Okay, uh, so once again, voluntary alienation is something you wanted, something you went out of your way to do, right?
Yep.
Voluntarily. Involuntary alienation is something you didn't want. It was without your consent. Right now, we're just talking about transferring of ownership of property. Later on, we could be talking about different types of liens on property. You know, liens are financial obligations, right? Uh, you have voluntary ones and involuntary ones. Like a mortgage lien is a voluntary lien. You went out of your way to get it.
Mhm.
Taxes are involuntary. Who the hell wants to pay taxes? We got to, but you know, they're involuntary. Those are ones that are imposed on us. But we'll get into that later on. So, you guys got these notes highlighted down?
Yes.
Yes.
So once again, involuntary alienation is without the owner's consent. This could be done by escheat, eminent domain, by unpaid debts, by foreclosure. You know, you don't pay your taxes, you don't pay your mortgage loan, you could get foreclosed on. By court action with like a partition proceeding or suit to quiet title. By adverse possession through an easement by prescription. However, easements, you don't just automatically get the ownership of somebody's property if you've used it for a long enough period of time. You actually have to perfect this type of easement in a court of law by taking the owner to court and claiming the ownership. Some people refer to this as squatters' rights, but it's not just automatic. You got to take them to court. And erosion. This is by Mother Nature, right? Mother Nature can take away your land by wind or water. That's involuntary alienation, right? And so here on 375 on second paragraph, we just got the definition for what a partition proceeding is, where one co-owner sues another, forcing them to divide the property physically if possible, but if not, then forces them to sell it. So here we have some examples of involuntary alienation. When a person dies intestate and no heirs can be located through the process known as escheat, the state gets your property. If a land is needed for a greater public use through the process of by using the powers of eminent domain through the process of condemnation, the government can take your property and justly compensate you for it, though. And then the governmental or public utility company can get it. If you don't pay your debts that are secured by real estate through the process of foreclosure, the sheriff will take the property and sell it to the highest bidder at auction. And through open, notorious, continuous, hostile, and adverse use of another person's property for a prescribed period of time as prescribed by law, a person can take your property by adverse possession, also known as an easement by prescription or suit for adverse possession. Then the adverse possessor becomes the owner. So you guys already have this highlighted, right? Partition proceeding, one co-owner seeks to force or divide, seeks to force another to divide or sell the property.
Yep.
Yeah.
Got it.
All right, let's talk about an easement by prescription here, through or adverse possession. An easement, first of all, we didn't discuss easements yet, so let me give you a quick little rundown of the word easement. What is an easement? It's the right of another person to enter your land for a specific purpose. Once it's been established somebody has rights, you cannot take away their rights. You can't violate their rights, right? You can't take away someone else's rights. So if somebody has the rights to enter your land for a specific purpose, you cannot take that away from them. However, an easement by prescription, this is when somebody's been using your property against your permission for a long enough period of time as defined by law. They can gain rights of ownership of your property. However, this would require a court action for them to make the claim to gain those easement rights of ownership. So some people refer to it as squatters' rights, but squatters really have no rights. You know, you could remove them at any time. However, if you're always bitching and complaining about this person using your property or being on your property and you take no action to remove them, and they're there for a long enough period of time as defined by state law, whatever that time frame is, they can claim ownership of it. So when you use someone else's property for a period of time as defined or prescribed by state law, you can claim ownership of that property that's being used. To perfect this easement by prescription, it requires a court action called a suit for adverse possession or a suit to quiet title. You're basically asking the judge to rule in one person's favor over another as to who's the owner. The use must be continuous, hostile, adverse to the owner's title, exclusive, and without the owner's approval. Additionally, the use must be visible, out in the open, and notorious that you're using their property.
What do you mean by hostile?
Um, Against your permission, you don't want them there, but they're there anyway. That's hostile, right? Um, the prescriptive period in New Jersey is 30 years for improved lands and 60 years for unimproved lands. That's what you need to know for exams. That's what you need to know for exams.
Yeah.
It is required to make that claim. Now, this law is going to be changed at some time in the future. They're going to remove the 30-year and 60-year period in favor of a 20-year common law period. However, our politicians already created the law and put it up to be voted on about 16 years ago. We're still waiting for them to vote on it. I've been tracking this for about 16 years now.
What's taking so long?
I don't know. They want to pass a gas tax. They do it in 30 days, right? They're in agreement on what they want to do here. And it's been sitting on their docket waiting to be voted on for the last 16 years or so. I've been tracking this. As a matter of fact, if you look at the last 5, 6, 7 versions of this book, it's been changed so many times because even the publishers, the book manufacturers, the writers, they're not sure what's going on because they know that there's a 30-year, 60-year, and a 20-year law in the book. So they're not sure what it is. And their wording, their language changes with every issue here. But I'm aware of what's going on because I've been following this specific issue here because there was a court case where it was 2 commercial properties, right? 2 businesses. One actually was using another's property. They actually put a fence around it, and it's been there for 60 years. And so now they take them to court to try to claim ownership of the property. And the argument was brought up. Okay, so you've been there for 60 years. It's unimproved woodlands. They put a fence around it. So, yeah, they've been using your property. However, the argument was, yeah, but there's also a 20-year common law on the book that says that after 20 years, you have to take the other party to court. So this created a conflict in the law because our politicians wrote too many laws covering the same topic. Go figure. Politicians trying to be the heroes. They always want to create new rules, even if there already is a rule on the book making something illegal, right? They try to write a new law about it. We've seen this happen in recent years with stuff that's going on with Trump. But he's no stranger to politicians creating laws when there's already laws on the books and they're too lazy to look it up, or they want to seem like a hero and write a new law. I wrote a new law to protect. There was already a law in the books about it. You didn't need to write a new law. Okay. And when they write new laws, sometimes they conflict with existing ones. And that's the case here. So they were not able to successfully win this lawsuit because even though one law that politicians wrote said you had to use the land for 60 years before you could successfully claim an easement by prescription, another law said, yeah, but you got to take it to court after 20. So there's a conflict in the law. So good thing the judge did not make a ruling. Instead, he said, there's too many laws covering the same topic. As a judge, my job is to interpret laws, not make them. So we're going to kick this back to the politicians, and this case is dismissed, and we're going to kick it back to the politicians to fix the problem that they created. And like I said, I've been waiting 16 years or so for them to fix this, and they still haven't. I mean, they wrote what they wanted to do, but they just haven't actually ratified it. They haven't voted on it and put it into law yet. So for us here on exams, the law is still written on the books. It's 30 years for improved lands. What's an improved land? What's an improvement? It could be a paved road. Anything, any man-made manufactured addition to a property classifies it now as real estate because it has an improvement on it, right? Land with improvements is now real estate. Otherwise, 60 years for unimproved woodlands with no improvements. So you need to know 30 years and 60-year period for exams.
360.
You're not going to get the 20-year thing. That's a common law. Now, through the process of tacking, an individual who was not there for 30 years or 60 years, they were not there for the prescribed period of time as required by law before they could file the claim. They could add on or tack on one person's time of usage onto another to reach the prescriptive period to successfully make a claim of adverse possession. However, they have to be successors in interest, like a landlord and a tenant, an ancestor and an heir, or a seller and a buyer. They could add one person's time of possession onto that of another, combining them to reach the prescriptive period. So, how do you prevent an easement by prescription if you realize somebody could make that claim against your property? Well, you could take legal action to get that person removed from your property. Or you could cut off their direct access. This stops the continuous use and resets the time clock. So if somebody's been using your property for a period of time and they have not yet claimed adverse possession, you could cut off their access to your property and that resets the time clock. Or you could give them permission to use your land. An easement by prescription cannot be claimed against land where owner gives you permission to use it. So that would also reset the time clock there as well. But look, we could do this. How do you prevent somebody from claiming easement by prescription to taking your property? Send them a certified letter giving them permission to use your land till the end of the month, and then they got to go. You gave them permission, so you reset whatever time clock for whatever time period they've actually been using it for already. Now, there's a little note I put there at the bottom. An easement by prescription cannot be claimed against publicly owned lands. Any government-owned property, you cannot claim an easement by prescription.
So if they're using they're using your land, let's just say, right? Where are you sending them a certified letter to your own land?
Sure, you could have a process server go
Like
and serve them.
have someone
Yeah,
serve them the letter. Okay.
yeah, yeah. Mm-hmm. Now, an interesting little factoid here. Did you know that any land that was not claimed for private ownership in the United States, you could just simply claim ownership of it and become the owner?
No.
Well, we can't do that anymore. But at one point, it was like that. Up until I think the last place in the United States, I think, was in 1987. So, all the way up to 1987, any land that was not claimed for private ownership, you could claim it and become the owner. That's how we started giving land here in the United States. All you had to do is pay the filing fee for the paperwork and you became the owner of the land. You know, So let's highlight this in the book, I guess. This is on page 375.
275.
Yeah. Now, if a person's able to successfully claim adverse possession and easement by prescription in a court of law, uh, there's the owner has no recourse after that time. They lost the property. But like I said, thank God we had a judge in New Jersey that had a level mind and was not one of those activist judges that legislate from the bench where the power goes straight to their head and says, I'm going to rule on this, even though there's conflicting laws. I'm going to rule on this and set a precedent and make a law, a de facto law, by making a ruling. That that could cause all kinds of problems all on its own. Look no further than what was that, Roe versus Wade, the abortion law. You remember a couple of years ago how that created a problem in this country?
Yep.
You had, you had President Trump. He said, "Well, there's a court case that's over here in front of the Supreme Court." At least everybody was blaming President Trump. He had nothing to do with it. It was actually a lawsuit that somebody made, and it went up to the Supreme Court. They claimed that you got these 50 years ago, some judge ruled on a court case and created a de facto law by setting a precedent, but there was no law. You had Democrats that were screaming, there's a law, long-standing law in this country that made abortions illegal or made abortions legal. And somebody took it to court and they challenged it. They said, well, uh, who was the politician that wrote the law? And when exactly did they vote on this law? There was no law that was created. This was a precedent that was set by a judge who ruled on and made a decision from the bench, creating a precedent that was just followed after that. So they kind of legislated from the bench, creating a de facto law. But judges aren't supposed to create laws. They're not supposed to rule on cases where there's no precedent. When they do that, they create a law and they create problems. Well, they don't create a law, they create a precedent, and then all other judges follow that precedent. But it's not a law, it's a de facto law, that's created because they started a precedent. And that's what was the problem that was out there. And now you have all these people that are like, oh, there's been a law for the last 50 years in this country that it's legal. No. Who created who made the law? Who voted on it? You see, it becomes a big problem the longer that it's out there. And so the Supreme Court said they overturned Roe versus Wade. They said, no, there is no law on the books.
Mhm.
If Congress wants to, they could create a law and vote on it, and then there will be a law of the country of the land about pertaining to it. But yet, all those cowards in Congress that are like, there's a law, it's a de facto, it's a standard for the last 50 years. Well, it's not, obviously. So why don't you make a law on it? All those cowards refuse to do so. Why? Because it's a thing to argue about the next election term. This is why people in politics here, our Congress and Senate, they don't fix problems because what do they get to vote? What do they get to run on as their argument next time? If they fixed all the problems, there's nothing for them to run on to fix, right? To get elected. So they don't fix problems. Instead, they just let them go and fester. But this was a good thing that this judge in New Jersey did pertaining to adverse possession, unlike the one with the Roe versus Wade case, who voted that the it was actually a case. If you guys are not familiar, he voted to allow this woman to have an abortion because she claimed that she was raped by somebody. And everybody's like, oh, yeah, she should be able to get an abortion because she was raped. Turns out she was not raped, actually. Later on, we found out. So we had a 50-year precedent based on a false premise that when a judge ruled and made a decision on something. So now all the thing is, there is no federal law pertaining to it. Each state now can create their own rules about it. That's the only difference. So it's not like Congress made abortions illegal. It just said that there's no law on it, and each state they could create their own. So this is how courts work. That's the only reason why I'm bringing this up. I don't care about your views on abortion or not. This is just about how judges sometimes legislate from the bench. This judge did not. He kicked it back to our lawmakers here in the state of New Jersey, but they still have not voted to fix it. Lazy politicians.
Hmm.
So, good question, Jonathan. How come they didn't vote on it? So, questions should be asked to the politicians when they run for office next time, huh? How come you guys got this legislation sitting out here for the last 16 years when there's a conflict in a law because you wrote too many laws? Or you could pass a gas tax in 30 days. How come you can't fix this? Why don't you put it up for a vote? All right. So now here's an interesting thing here. Property owners who feel that new government requirements have taken away their rights on how to use their own land or develop their own property may seek damages under a concept called inverse condemnation. So let's stop there. Let me explain a little bit further. What are they talking about here? Municipalities, they create zoning laws and zoning ordinances that dictate what kind of structure can be built where and for what purpose it could be used for. They also create environmental protection laws that may say that you can't build this close to the water, or you got to have a setback this far away from the road. When the politicians create so many rules that it affects how you could use your property to the point that they render it useless or they devalue it, but yet they never took your property by eminent domain or compensated you. Instead, they just created a bunch of laws that limited how you could use your own property. A landowner can sue the government through what's called inverse condemnation. They're saying basically, you condemned my property, so I can't use it anymore by creating all these laws, rules, and regulations, but you never paid me for it. So the burden is on the owners to prove the government's action has taken the rights away of the property owner without compensation. And then the government would have to pay them. So that's an interesting little concept. And, you're not going to get this on exam, inverse condemnation, but it's an interesting concept that knowing it, as a teacher, I do this stuff. I teach this stuff all the time. So I come across this all the time. So it's always locked in my head. These little bits of knowledge are good to have. I actually came across a situation where I gave advice to a mayor of a town. I said, because a group of people I was with, we were consulting with the mayor on something, and he's talking about something that he wants to do in the town, and it's basically taking away the rights of a property owner. He wanted to force this lady to not be able to, or to require her to sell to a developer or to build up, and she didn't want to. She wants to keep it like a historic district, commercial district. This was actually in Metuchen. I advised the mayor, I was like, you better be careful. And you're wanting to create now all kinds of limitations on how she could use her own land because you rather that she sell it to a developer so that the developer builds up the whole downtown area there. You guys are already building up the area, but she owns all of this property where she has all these commercial businesses running out of all these historic buildings. And you're wanting her to upgrade basically and then get more taxes for it or whatever. As like, by putting more restrictions on her as the property owner, you're devaluing her property and limiting on how she could use it. She could actually sue you and force you to pay her due to inverse condemnation if you keep putting restrictions on her. He actually had to look it up and consult with his attorneys, and he was like, yeah, you're right. I gave him a warning. of his plans, because I'm more for the individual property rights and the individual's owners over government. I'm for smaller government, not more intrusive government. You own land, you should be able to do whatever the hell you want with it. These are people now that they decide that they want to use your land for something, or they want you to use it in a certain way. It's your land. You should use it how you want. So I gave him that little bit of advice, and now he dialed it back a bit. The aggressiveness of taking away land, or and turning it over to developers and such, or creating so many rules that they restrict the hell out of you that you can't use it anymore. That you just say, screw it, and you sell it. All right, so here is in chapter 6. We're going to be going back. No, don't go back to chapter 6 right now. This is just a screenshot from chapter 6, which we're going to be going to in a moment, talking about an easement by prescription, just showing you how their own definitions vary a little bit. Because if you see here, they explain what an easement by prescription is, and said the claimant's use must have been continuous, hostile, adverse to the owner's title, exclusive, and without the owner's approval. Additionally, the use must be visible, open, and notorious. And then it goes on to say, New Jersey's law is silent as to the required number of years, although court cases appear to support a minimum of 30 years of adverse use and 60 years if it's considered woodlands. No, the court cases are not silent. It's that nobody can win an adverse possession suit right now in New Jersey because there's a conflict in the law that our politicians created that they still have not fixed in the last 16 years or whatever it is. Okay. So even the book manufacturer now, because they were always saying 20 years, then they bounced back between 30 years and 60 years, they're confused. So they just wrote now, New Jersey's law is silent. No, it's not. It's not silent. We're waiting on politicians to fix the laws. All right. Anyway, moving along. How do we transfer a deceased person's property ownership? Well, title is the word that means ownership, and there's no document in real estate called title. Deed is the document that transfers your ownership while you're alive. Your will is what determines who gets your property after you die. So transfer by title by will is known as devise. The devisor is the person who's leaving you the property in a will, and the devisee is the one who's named in the will to receive that property. Testate means that you prepared a will stating how you want to dispose of your assets after you die, who you want to get your stuff. Did you work hard all your life to gain all the stuff that you got right now? Your car, your house, your money in your bank, your jewelry, whatever assets that you may have, just for the state to get it when you die? Or would you like maybe some family members to get it? Or if you got no family members here, maybe you want friends or even a charity to get it instead of the government, right? Well, you better have a will. You better have a will if you got kids, right? I don't care how old you are. Anybody can drop dead at any moment, right? Especially if you got kids, you should have a will. I mean, your kids are your natural heirs, so they could claim it, but you could streamline the process and make it a lot smoother for them to get it without all the hassle if you have a will. The probate goes a lot smoother. So transfer by title by descent takes effect after you die. And every state has their own laws of descent and distribution, specifying who can inherit your assets upon death when you die intestate. What does that mean?
They have not prepared will.
When you died without a will. So intestate means you have not prepared a will. And this form of alienation is involuntary because you didn't get to decide who gets your stuff after you die, if you die without a will. The government's going to decide that. Now, consult an attorney about making your will and what your options are. So let's do some highlights now on page 375. Intestate means without having left a will. Testate means you prepared a will. And all wills must be probated, meaning that all debts must be paid, especially any unpaid taxes or claims from creditors. Probate or administration is the legal process where a court determines who inherits the property of a deceased person and what their assets of their estate are. Either an executor or an executrix, if they're a female, named in a will, or an administrator, if you did not name an executor or an executrix in the will oversee the distribution of your assets of your estate. So if you didn't name an executor or an executrix in your will, the court will appoint an administrator who will get that job. So just write your notes, highlights, and let me know when you're done.
Got it.
Got it.
Got it?
Yep.
Okay. So once again, we got this slide. I showed it to you in chapter 5 already. Talks about the different terminology. That once again, we'll just go over it again briefly. An heir is a natural blood relative who can inherit your belongings. All right. So even if you didn't have a will, an heir would be a relative who can make a claim against your estate. Devise is to transfer property in a will. You could leave it to someone in your will. The devisor is the one who creates that will and leaves it to you in a will. The devisee is the person who's named in a will to receive those belongings. Don't confuse the word devise with demise, which is a transfer of property by lease. Testate means you made a will. Intestate means you did not. Testator is a man who makes a will. A testatrix is a woman who makes the will. Probate is the court proceeding that determines who all the natural heirs are, or to confirm the devisees that may have been named in a will. No matter if you had a will or not, your assets have to go through probate to make sure that all debts have been paid and before anything is distributed to heirs or devisees. And an executor is a man named in a will. Executrix is a woman named in a will. They're a trusted person that you named to make sure that all your final wishes were carried out as you wrote in your will. And if you did not name somebody in your will to be an executor or an executrix, the court will appoint an administrator to handle those duties. Descent and distribution is the law that determines who gets your stuff when you die intestate without a will. And when you die intestate, if no heirs can be located, your property will escheat. That means it will revert to the state. The state will sell your property at auction, put the money in a fund for a year, in which time your heirs can step forward and claim it, because the government's most likely not going to go searching for them. And if nobody claims it, they keep your money. And the legacy is your personal assets that you've amassed during your lifetime. And the bequest is your wishes and who you wish to get it. Dower and courtesy are those New Jersey ancient rights between husband and wife, where the wife's right is dower, because dower begins with a doe, and a doe is a deer, female deer. So that's the wife's right. And courtesy, because men should be courteous to women, is the husband's right. That's the way to remember which one is the wife's right, which one's the husband's right, because you need to know for example. So dower is an ancient right in which the wife has certain interest in her husband's property upon his death that he owned during their marriage. And courtesy is a similar right that the husband has in the wife's property that she owned during their marriage. New Jersey abolished the creation of any new dower or courtesy rights on May 28, 1980, a date you must memorize, because if you were married after May 28, 1980, your spouse has only the right of joint possession of the primary marital residence. Any other property they could leave to you in a will, of course, but you could leave it to other people as well. But your spouse, if you were married before May 28, 1980, your spouse has an interest in all the property that you've owned during your marriage there. All right. So it's important for us as real estate agents to know, because if you're married before May 28, 1980, and only one spouse is listed as the owner of the property, well, you both still need to sign any relevant documents to sell it. Your spouse has interest in that property, even if their name is not listed as the owner. If you're married after May 28, 1980, your spouse only has rights in the primary marital residence. So if only one is listed as the owner, only one needs to sign any relevant documents to sell it. Okay, and then we have that missingmoney.com and unclaimedproperty.nj.gov. New Jersey pulled out of missingmoney.com, but other states still participate. Look up your name and look up your family names, relatives on missingmoney.com and unclaimedproperty.nj.gov. These are government-owned websites. They don't require you to make a payment to use it or a credit card or anything like that. If it's asking you for that, you're not on the website, okay, on the right site. I teach these classes and I tell all my students, go there, put your name in there, search your relatives. And I have one girl in one of my classes. She's like, I went to the website, missingmoney.com, and it asked me for a credit card. I put the credit card in there. Now they're charging me $28 a month. I'm like, no. What you
Wow.
did is, yeah, she went to Google and she typed in missingmoney.com. And you know how it comes back the results, and the first few results are paid ads. She took her to some other nonsense website. She wasn't on the right website. So make sure that in your browser window you type missingmoney.com or unclaimedproperty.nj.gov. Search your name, search your relatives' names, your parents' names. You may let me know if you guys find something. Okay, do this during lunch at least. Search it. You never know. You may have some money coming your way. All right. So transfer of title by will. All right. So just a reminder, as I go through these slideshows, I'll have some screenshots from the book with highlights already there. Don't wait for me to tell you to highlight. Start highlighting and take in any kind of notes that you see. And then I just go through them, explaining them, and then we move on. Okay, so a last will and testament is the instrument made by an owner to voluntarily convey title to the property after their death. So real estate ownership is transferred while you're alive by a deed. After you die, deeds are no longer valid. It goes according to your last will and testament. That's how we transfer the ownership after you die. So a will takes effect only after the death of the descendants. Until that time, any property covered by a will can be conveyed by the owner while you're alive. So you should update your wills periodically as well, because you may have sold your property while you were alive. And if you don't update it, if in the will you said you were leaving your property to someone and you no longer have that property because you sold it, you should probably update your will. So a party who makes a will is known as a testator. That's a man who makes a will. Testatrix is a woman who makes a will. The gift of real property by will is known as devise. And the person who receives real property by will is known as a devisee. A gift of money or other personal property is a legacy or bequest, and the person receiving that personal property is a legatee. Now, in New Jersey, children can be disinherited. So be good to your parents. No, I'm kidding. Don't be good to your parents just because of that. You know, you should always be good to your parents. They brought you into this world, right? So a surviving spouse is entitled to at least 1/3 of the estate, and a determination of the augmented estate is a complex calculation. In a case where a will does not provide the minimum statutory inheritance, the surviving spouse has the option of informing the court that they're willing to take the statutory share rather than any lesser share that was provided for in the will. And this is called the right of election, and it's reserved only for a surviving spouse. You know, when your spouse didn't leave you anything in the will, or they left you less than what the law requires them to. Now, a will differs from a deed in that a deed conveys a present interest in real estate during the lifetime of the grantor, while a will conveys no interest in the property until after the death of the testator. So to be valid, a deed must be delivered during your lifetime. All right. When does the transfer of property ownership take place? Upon delivery and acceptance of the deed itself. This is why deeds do not need to be dated or signed by the buyer. They need to be dated and signed by the seller, but not by the buyer, because the transfer of ownership takes place upon delivery and acceptance of the deed itself, the document. All right, so the parties named in a will have no rights or interest as long as the party who made the will is still alive, because a will only takes effect after you die. Okay. Everybody got these notes? Everybody good? All right. So chapter 7, you don't got to go turning to chapter 7 right now. This is just to show you a glance about remembering legal terminology. I already explained this to you guys, but I'm going to explain it again really quick. If you know what the root word means, if you know what any of these words mean, if they end in OR, you slap an OR at the end of them, that's the person who's giving whatever the root word or the product is. And words that end in EE is the one who's receiving whatever the product is. So devise is a transfer of property by will upon death. So the devisor is the one who made the will and is leaving you their property, and the devisee is the one who's receiving it, as an example. You know, when we transfer the ownership of our property, we grant our ownership to someone else, whether we're selling it or giving it away. So the grantor is the person who's giving you or selling you the property, and the grantee is the one who is receiving it. Okay. All right. Oh, no. By all means, you guys can take screenshots all you want. Listen, you could ask questions too. You don't have to send me chat messages. You guys just open forum, just like a classroom. Okay. So you got questions, you just ask them openly. Yeah. Screenshots, screenshot away, take pictures, record, whatever you like. I record these classes too, my explanations and these videos, and I'm going to share with you guys the playlist of videos that I just keep adding. Okay, I'm just gonna have to make up for yesterday because I was absent. I had another instructor in here teaching the classes who didn't record them, so I'm going to take yesterday's class lesson for the remainder of chapter 3 and 4 from another class, and I'll add it in here, okay, to the playlist. But I'll send you those I'll send you those playlists a little bit later, or after we're done with this chapter. I could share it with you. I already have the link to it. I already started.
Thank you.
Sure. Okay, so the legacy is the personal property that you've amassed during your lifetime. So the legator is the one who leaves you that property, and the legatee is the one that receives it. A lease. Does anybody know what a lease is? It's where an owner intentionally conveys to you their real estate for a limited period of time as well as all their rights to that property, except for the right to sell it or mortgage it, um, for a limited period of time as defined in the lease. So, who gives the lease? The lessor. And who's the lessor who gives the lease? We all know that's the landlord, right? But sometimes if we use these terms lessor, lessee, people get a little mixed up. They get it twisted up. So it's easy to figure out because the words that end in OR is the one that's giving it. So the lessor, that's the landlord, and the lessee, that's the tenant. Now, the word mortgage, well, people get that backwards all the time because a lot of people don't know what a mortgage is. Anybody here know what a mortgage is? It's a promise to pay. It's not a loan. You could have a mortgage loan, which means that the borrower is giving a promise to pay to the bank. In return, they give them a loan. That's a mortgage loan. But a mortgage itself, if you just see the word mortgage, it's simply a promise to pay. And banks don't make promises, they make loans. So the mortgagor is the borrower. That's the easy way to remember it. Just remember my annoying voice stuck into your head singing, the mortgagor is the borrower. Otherwise, I'll give you a couple ways to remember it. The word mortgage has two O's in it. The word borrower has two O's in it. The word mortgagee has two E's in it. The word lender has two E's in it. Or you can remember the whole story. Banks don't make promises, they make loans. It's the borrower who gives the promise to the lender that they'll pay them back according to the terms in the note. And if they fail to do that, they could foreclose on them, take the property, and sell it at auction to pay off the debt. All right, but that's too much. It requires you to think. I like the KISS concept. You guys know what that is, right? Keep it simple, stupid. Don't make me think, right? That's the concept I like. So the mortgagor is the borrower. I like the dumbest, simplest way to remember things. I don't know about you guys. That's works for me. All right. So we don't need to run down this whole list. We'll go over these things again, but just shows you, the words easier. It makes it easier to remember the legal terms. The words that end in OR, that's the one who's giving whatever the root word's talking about. If you understand what the root word means, well, then you'll figure it out. And the words that end in EE is the one who's receiving. All right. So let's continue about how do we make a will? What are the legal requirements for making a will and having a will? Well, you got to be of sound mind and legal age in order to make a will. The drawing of the will must be a voluntary act, free of any undue influence by other people. Any person of sound mind who's 18 years of age or older can make a will devising their real property. All wills must be in writing to be valid. So what, video wills aren't legal? Nope. You can make them for dramatization purposes, like they got them in movies, but it has no legal force. I actually stopped the class one time and called an attorney and had him tell us because I wasn't sure. Somebody asked me, are video wills legal? And I was like, I don't know. Let's call an attorney. And I called an attorney and he said, nope. And he said, the video will is just for dramatization so that they could see, you're speaking to them, whatever, but you need to have it in writing too. And, as long as it doesn't conflict with what you got in writing, it's fine, but you have to have it in writing. So the general rule is that a will must be witnessed by two people. A beneficiary can serve as a witness for a will in New Jersey. If the signatures of the witnesses are notarized in a timely fashion, they say within 2 days here, probate proceedings are simplified. A holographic will, that's a completely handwritten will, doesn't require any witnesses because it's harder to forge an entire document than simply a signature. That's why, if you print out, you get Quicken Willmaker or Susie Orman Willmaker software or something like that, and you make yourself a will instead of going to an attorney to get it drawn up, and you print it out and then you sign it. Well, it requires two witnesses. However, if you completely handwrite the will, no witnesses are required. because it's harder to forge an entire document. But it still needs to be signed and dated by the testator. That's the person who makes a will. Now, under New Jersey planning law, holographic wills can be probated and will serve to ensure the testator's assets are bequeathed according to their testator's wishes. And for real property acquired by married deceased persons before May 28, 1980, what significant thing happened then? New Jersey abolished the creation of any new dower and courtesy rights. Okay, and let's just give a little recap. We got a new person here right now, so let's just give a little recap. Dower begins with a doe. And what's a doe? A doe is a deer, a female deer. So dower is the wife, the female's rights, in all of her husband's property that he owned during his lifetime upon his death. And courtesy, because men should be courteous to women, is the right that the husband has in all the property of his wife upon her death. So New Jersey abolished the creation of new dower and courtesy rights on May 28, 1980. So if you were married before this date, you still have dower and courtesy rights. It's just that after that date, there were no more dower and courtesy rights. Now, married couples only have rights to the primary marital residence. Your spouse can own a property that you don't have any interest in. Okay, so if you're the only one listed as the owner, only your signature is needed in order to sell a property or list it for sale or sign any contracts. If you're married before May 28, 1980, you have dower and courtesy rights. So your spouse does have an interest in all the property that you own. So therefore, we need, even if only one is listed as the owner, both have to sign any relevant documents to list property for sale or the sales contracts, etc., even if only one is listed as the owner. That's why it's important for us to know and why they give this to you on exams. Hint, hint. Okay. So, the surviving spouse is still entitled to a life estate of 1/2 interest in all real estate owned by the deceased, no matter what other provisions were made for it in the will. So you can't write your spouse out of the will. Well, that's not true. You could write your spouse out of the will, but they could be like, nah, I'm going to exercise my right of election, meaning your spouse had to leave you a minimum amount by law. Okay, so title the real estate and personal property of a deceased person, of a person who dies intestate. What does that mean? Without a will. It passes on to their heirs. Under the descent statutes, the primary heir of the deceased are your spouse, civil partner, or domestic partner, and close blood relatives. Now, when children have been legally adopted, okay, well, this has thrown us for a little loop here. When children have been legally adopted, you're not a natural blood relative. So can you claim to be an heir? Well, children that have been legally adopted, most states consider them to be heirs of the adopting parents, the mother and father, but not the ancestors of the adopting parents, their aunts and uncles and so forth, because they're not truly a blood relative. Now, if they wanted to, they could leave you something in a will, but you can't just step forward and say, I'm claiming I'm related to them. I have a right to inherit. No, you don't. Only blood relatives do. Think of it in the Game of Thrones way. Can you inherit the throne? Can you claim the throne if you're not if you're the bastard child? Or you know what I'm saying? So this is kind of like, these laws are kind of medieval too, like in that regard. Because take a look at this next sentence here. We're not talking now about adopted children. In most states, illegitimate children inherit from the mother, but they do not inherit from the father. Wait a minute. What's an illegitimate child? An illegitimate child is when you were born out of wedlock. You are the bastard child, right? In the Game of Thrones language. So your parents were not married when you were born. And that's actually a pretty common thing these days. You get a lot of people that have kids that aren't married to each other, okay? But this is the harsh sounding language of the law. It says in most states, illegitimate children inherit from the mother, but they do not inherit from the father. That's interesting. Unless he admitted parentage in writing, or parentage has been established legally in some other way, like a paternity test or blood test. Now, if he legally adopts such a child, that child inherits as an adopted child. Hmm. You know, there's another little twist to this I could lay out there from personal experience. Um, what if you what if you're married to someone? You know, you're going to get a divorce, and your wife has a kid with someone else, but you're still legally married. Are you responsible for that child?
Yes.
Yeah. In the eyes of the law, you're the father, and you're responsible for all the money to take care of that child, etc. Which this is pretty interesting because I had something like this happen to me too. And my mother just recently watched something. My mother or somebody at Pool League, I forget. They said that they saw something like this on like one of those courts, you know, on those court TV shows, where there was a guy that was paying. Oh, it was my mother. She was watching like Cutler's Court or something like that. She saw that this guy was paying child support for years. Um, and then he got a paternity test and it found out that it wasn't even his kid. So, and she was suing for more money from him. And what do you think the judge said?
Still married, so he has to pay.
You still got to pay for the kid. You're not getting any of the money back. I highly suggest you petition this and get divorced ASAP.
Yeah.
and then you need to go there to the court to show that you're not the father, so you could stop the payment, the requirements. But until that happens, you're legally responsible to be paying for this kid, the child support. How effed up is that?
Mhm.
All right, let's move on. That has nothing to do with this course, but it's just interesting stuff nonetheless. You know. All right, so what happens now if you die without a will? Who gets your stuff in New Jersey? According to New Jersey law, who gets your stuff if you die without a will? Who, first of all, who can lay claim to it?
An heir.
An heir. That's a natural blood relative, right? So intestate real property is distributed according to the laws of the state in which the property is located. So that could vary from state to state. But New Jersey's law of descent and distribution, which dictates who gets your stuff after you die, if you die intestate, that means without a will. The laws of descent come into effect only when the descendant leaves no will. A surviving spouse or partner becomes the sole heir if the descendant leaves no parents or children. If there's a child or children who are also children of the surviving spouse, the spouse or partner receives the first $50,000 plus one half of the remaining estate. The rest goes to the child or children. If a descendant leaves parents and a spouse but no children, the spouse or partner receives the first 50,000 plus one half the remaining estate. The rest goes to the parent or parents. Now, if there are children who are not the children of the surviving spouse, the spouse or partner receives half the estate and the child or children the other. Where no spouse or partner survives, children become sole natural heirs. And where there's neither surviving spouse nor children or children's own heirs, the estate first goes to parents, and failing that, to brothers and sisters or their heirs. In default of any other natural heir, grandparents, aunts, uncles, and first cousins only may be considered heirs. Beyond this point, the entire estate goes to the state of New Jersey by escheat. There's that word again that we need to know. So, what is escheat? Well, the state treasurer sells the property at a public auction, a public sale, that's an auction. They give notice by publicizing it in the newspaper in Trenton and the major newspaper in the county where you live in. where the property is located. And the proceeds of the sale are held in a fund for 1 year. And if nobody makes claims to it, the state gets it. And they get to blow your money on however they want to blow it. So, once again, another reason why it's important for you to have a will. Do you want the state to get all your stuff when you died because you didn't have a will? I suggest that you get one written up. So once again, unclaimedproperty.nj.gov or missingmoney.com, which New Jersey pulled out of and doesn't participate in it anymore. You should look up your names and your relatives' names. See if there's anything owed to you guys. Like I said, I usually have at least one person in every class that finds something for themselves or their relatives. Did you guys look at all during lunch hour if you had anything that was owed to you? Find anything?
Yeah, I got
No?
nothing.
No. Kev, you find nothing? Did you look? Try to unclaimedproperty.nj.gov, but also try Missing Money. Missingmoney.com
I
is
did
good for
both.
other states, but unclaimedproperty.nj.gov is specifically for New Jersey. Okay. New Jersey doesn't participate in that other one anymore.
Hmm.
All right. So that concludes chapter 20. So let's do the key terms to review for chapter 20 now. Now, the way that this has been working is like this. I read out the phrase or the answer on the right-hand side of the page. You guys shout out what you think the correct corresponding term is to it on the left-hand side. There's no penalties for wrong answers, so shout them out as you get them. Are you ready?
We are ready.
All right, let's do this then. Before we get started, go down to letter L. This is page 378. Go down to letter L. And right where it says one who can inherit, write blood relative next to that. Of course, the only exception to that is adopted children for just the parents, the adopting parents. Oh, by the way, since we're talking about this, do you guys see what happened yesterday? What President Trump signed into law?
Nope.
Or signed as an executive order, extending rights for foster children, because a lot of times they age out of the system. He signed into law an extension for foster children to continue being able to get the benefits from their through their foster parents. So
Cool.
that was pretty good, because a lot of times when foster children age out of the system, they often become homeless. So that was a pretty good thing. Wonder why nobody else ever did that before. All right, let's do the key terms of review. Ready? Person named by the state to administer a descendant's will.
Executor.
A person named by the state
Oh,
to administer a descendant's will. So if you didn't name somebody to be an executor or executrix in your will, a judge will appoint somebody to do that job. And what do they call that person?
Administrator.
An administrator. So one is A. Court proceeding to establish validity of a will.
probate.
10 is B, probate. Title acquired by usage. You get ownership of property simply by using it for a long enough period of time. Against the owner's permission. Hostile. For a long enough period of time.
Adverse possession. You said it doesn't count against us if we guess wrong.
Yeah, okay. So it is adverse, but it is adverse possession, actually. 2 is C.
Cool.
A person named in a will to administer a descendant's estate. A person you name in a will.
Executor.
An executor 5 is D. You know what? Right next to that, I'll put a little slash and write executrix as well, because an executor is a man. Executrix is a woman that you name in a will. Okay. Executrix. Yes, the law is just like most languages, it's based in Latin, and most languages have gendered terms. Okay, so 5 is D. Transfer of title without the grantor's consent.
Involuntary.
It is involuntary alienation. Correct. 8 is E. Without having a will. Without having made a will. What do we call that? If you die without a will, what do we call that?
Intestate.
Intestate. 7 is F. One who makes a will. What do we call the person who makes a will?
The testor.
Testator, correct. Or testatrix if they're a woman, correct. Testator is a man who makes a will. Testatrix is a female who makes a will. So 12 is G. Okay, a document disposing of property after one's death.
Last will and testament.
Yeah, the will, last will and testament. 9 is H. Having made a will. What do you call it if you made a will? You died with a will.
Shit.
Hopefully not.
If you wait.
Testate. Testate.
State.
We've seen before that if you die without a will, it's intestate. And if you die with a will, it is testate.
Testate.
So 11 is I. Acquiring of property by natural heirs.
Wait, I just messed up.
Okay, what'd you mess up?
11 is I.
Correct.
Then F. What's F?
Um,
Oh, I said 7. I got it right.
without
I said it right, but
7,
wrote
yeah.
it wrong.
Yeah,
Got it.
okay.
Thank you.
You're welcome. All right. What did I just say? Where were we at here?
11
Next
is
is
I.
J, acquiring property by natural heirs.
Yes, acquiring of property by natural heirs. What is that?
Is that voluntary alienation?
Mm-mm.
Die inherit. Number 6.
Nope.
Heir.
Or is it number 3 at that?
Remember, we just read a whole list of this New Jersey state law of who can get your stuff after you die. What do we call that law? Every state has a law of descent and distribution. So it's descent. 3 is J.
J.
Descent is acquiring a property by natural heirs. Only natural heirs can lay claim to your property through descent. They're your descendants, right? Descent, descendants. 3 is J. One who receives real property through a will.
The devisee.
The devisee, correct. 4 is K. One who can inherit, those blood relatives.
Heir.
They're an heir. 6 is L. And transfer of title with the grantor's permission, with their consent.
Voluntary alienation.
That's a voluntary alienation. That is correct. 13 is M. All right, let's go back and we'll start chapter 6 now. Let me open that up. Oh, let me also finish this recording.